raised by Honorable Angeline Osege, Soroti woman member of Parliament, on alleged consideration by the Electoral Commission not to nominate candidates whose names on the national identification cards differ from those on the academic transcripts. The minister is here with the Electoral Commission to present the same statement to us for consideration before we report back to the House this afternoon. Honorable members, the committee has the following bills before it for consideration, and we shall need to devise means on how to go about them given this busy period of electioneering. The anti-slavery bill, can you imagine? 2020. The Constitution Amendment Bill number 2 of 2020. The Constitution Amendment Bill number 3 of 2020. The Sexual Offences Bill 2019. The Succession Amendment Bill 2018. The 5 succession-related bills, which as the administration of small estates, all related bills there, 2019. We shall meet to decide how to go about the above businesses the next week. We also have a bill on the order paper, the Constitution Amendment Bill 2019. This is the Nwagaba bill. We have it on the order paper. Yes. The MP, the only MP of Jema, and is the president of Jema, the whip of Jema, the Secretary General of Jema. We pray for him. And the chairman of IPOD, and the flag bearer, the only flag bearer known in Uganda for Jema. We pray for you. You're welcome, Honorable Smart.
Yeah, but you say you were missing me. You said so many things.
And honorable members, I would also like, this is not in the statement. Later on, I would like to hear from the minister and the Electoral Commission about the controversies surrounding the issue of women councillors from the sub-county to the district councillors. We passed an amendment that was very popular in the House, but we had the Attorney General citing Article 180 and 182B, and those in the forum where we are all there with the Attorney General, you had it up to midnight. I told him we shall meet shortly. Mr. Attorney General, we've met. We have to sort that out, and we shall be glad to hear from you. The determination of 1/3, and then you look at 182B in relation to 182D with regard to 78(2) articles. Those are all articles of the Constitution. And then also about Electoral Commission should be able to tell us, and the minister, about the age for chairperson LC3, LC5, and councillors. Has age been of a problem? There are some, the exercise is ongoing, but we've heard that at some areas your officials are turning away people who they are still considering the old legal regime of 30 for LC3 or 35 LC5. I hope not, but that is a concern that members have generated. So at this very point, before I invite you, the Attorney General, I would like to invite the man I have extensively introduced to say what I did not say about himself. Introduce yourself, sir.
Whatever your left can say.
We are not using the microphone.
Mr. Chairman, thank you. My name is Vasari Vasumali from Bugiri Municipality. You should have also told the meeting that you delegated me to represent you in a workshop. That's where I have been. I have carried your message from where you left me. I thank you.
Is there a bag? Okay, thank you very much. And the next is the staff. Even the staff here, I didn't introduce you. Did I? Okay, please, the staff, introduce yourselves.
Thank you, Chair. My name is Max Kumbech, I'm the Activities Committee.
Yes, thank you. Honorable Minister, we intend that this meeting should not take long. We know that we are all busy and we have to report about this matter today. You've not seen me ever since the Camille. And I should also have taken opportunity to thank members, and I should take right now those who went through the flag bearer, the NRM primaries, and those who did not, or are yet to go, because matters are yet to be determined. You can't get, there are about 455 petitions. Some of the petitions, when you look at them, that I was slapped at the polling station. I was pushed. But all the letters written as a complaint, they are called petitions. So somebody with 64 votes petitioning against somebody who got 22,000, that person bought off the agents. So, and the villages are 199. So those are all petitions. So, but there are areas where they outright misuse of I don't know what. So members, it is also for the record the first time I've been attempting to stand and nobody could declare me as a flag bearer winner outright. This is the first time in 10 years that I've been declared on day one that I am a flag bearer. So you are no longer an independent. Many of you do not know how I felt or how I'm feeling, because it's a new thing. I was used to campaigning as an independent, as a person who has been cheated, and that one was giving me votes. Now I will campaign the other way around. So, yes, so
Is that why you are wearing the badge of the man who has the vote? It has nothing to do with that.
Of all things, you've only seen the badge on me.
Usually see it.
You see, anyway, you are having me. Honorable Basalra, we've been together. Recently, I posted this photo when he campaigned in University Hall in 1999. Yes. The color of his suit and the shirt and the size of the trouser of the suit tells a lot of history that it's not by accident that he is a member of Parliament now. And we've come from far. Yeah? And that day he asked us in university that if you want to get what? A Monte lizard to sit, show it where it will put its tail. And people clapped and they voted him. Now, Honorable Minister. And you were also his voter.
Thank you very much, Chair.
Yes.
Perhaps I will need some more guidance because this is a statement I presented to Parliament.
Yes, you can either go through the highlights and give members copies formally.
We have.
Let the clerk distribute the copies of the statement. As the minister is going through them, we follow so that I don't think you will need to go. Yeah, but it's a short statement.
I could go through it.
Yeah. The background.
Okay.
How did this thing get to you to make a statement? Change of name.
Chair and colleague. My senior colleague has not introduced himself. and if I speak before introducing himself, he will consider that to be insolent. I have a lot of respect for him.
Yeah, since you come from the same region.
Yeah.
Introduce yourself for the record.
Yes. And please.
I don't know in singular.
We are not using that thing.
Aston Badera, Member of Parliament for Mange South, and a member of this committee.
Thank you.
Chair, that was out of respect
And you don't respect
for him. Is there another? Oh, I've not seen him. Thank you very much, Chair. Let me proceed.
Yes, please proceed.
A question was asked by Honorable Angelino Sege on the alleged consideration by the Electoral Commission not to nominate persons whose names on the national identification cards differ from those on the academic documents. Before 26 March 2015, when the Registration of Persons Act 2015 commenced, aspirants for elective positions if they had changed their names by reason of marriage would only require to present a sworn statutory declaration and a marriage certificate to the Electoral Commission when the names in the National Voters Register differ from the names in their academic documents. However, adult persons who change names completely would go through a deed poll, which is a legal process of changing names provided for under the Section 36 of the Registration of Persons Act 2015. Section 36 of the Registration of Persons Act 2015 states as follows: subsection 1, any person being over the age of 18 years, or a widower or widow, a divorced person, or a married person who wishes to change his or her name shall cause the publication to be published in a gazette, a notice in the prescribed form of his or her intention to change names. For the record, the form is hereby attached. Here, I wish to table this form that is envisaged in section 36, subsection 1.
You have only one topic for the chair?
Yes, NIRA did not come up very fast, but I think you'll bear with us. Yeah, subsection 2, not less than 7 days after the publication of the notice, the person intending to change his or her name may apply in a prescribed form to the registration officer of the registration center in which his or her birth is registered. Subsection 3, the registration officer shall, upon being satisfied that the requirements of this section have been carried out, and upon payment of a prescribed fee, amend the register accordingly, and shall sign the date and date the amendment. Here, allow me to present the regulations, the registration of persons fees registration, regulations 2016, specifically in reference to the fees payable, because that was an issue that also came up. Section 3.
Would it help our other listeners who may not access? How much is it?
It is 50,000.
Yes.
Yes. To be exact, it is 50,000. That is the. That would be point to something.
2.5.
Yeah. Okay. Section 3. of the Act defines the registration centers. I don't need to read this. Chair, upon presentation of this, an issue arose that when it comes to nomination, this section appears to be targeting women. And the issue was, how is the Electoral Commission handling it? Because the section appears to be more discriminatory, especially in regard to women who adopt their husbands' names. And I think that was the major reason we were asked to appear before you today.
And what is your response on that?
My response on that is that this section is not discriminatory. The only problem I find is that there are people who have adopted their spouses' names without necessarily going through the process, and that when they go for nomination, they do not carry with them the marriage certificates. I remember Honorable Ogwal, Cecilia, and the leader of opposition made mention of customary marriages. I do understand that many people have undertaken customary marriages, but probably they do not know that those customary marriages ought to be registered, and that upon registration they would have evidence which would be presented when it comes to nomination. So it is a mixture of people who have not known what is required of them by the law, and they find themselves in such a way that they have adopted a name and even added it to their national identity card, and they do not carry their marriage certificate. There was the other exception in this presentation. The exception was that if you had adopted your spouse's name prior to the coming into force of the Registration of Persons Act 2015, all that is required of you would be to present a statutory declaration as evidence when it comes to nomination. That's what I have to say for now.
And the registration of customary marriages is at the village, parish, sub-county, district, or center? Is that very far for most people? Where is that registration?
The major problem is that people do not even know that their customary marriages should be registered.
Yeah.
So the centers themselves being unknown is one thing, but the people knowing that it is necessary for them to register their customary marriages is another.
And usually is at the sub-county, which is not very far away.
And for the record, I wish to table the registration of persons regulations.
Okay. And the other
and the act.
The addendum to the statement, the addendum to the query as proposed by the chair, that we should also comment on the controversy that we discussed.
Okay. Oh, we do that once.
Yes.
Okay. Chair, there was an issue or two issues that have come up recently when it came to nomination and the primaries. One, as Parliament, we passed the local government amendment bill, and through that we provided that every sub-county be represented by a female councillor, departing from the current status quo, from the previous status quo, where every council was reserved for 1/3, where every 1/3 of the council was reserved for women. But as it turns out, Chair, upon that amendment, we realized that we ought to have started by amending the Constitution, because Article 180 of the Constitution indicates that the council of a local government shall have 1/3 of women. It does not say at least, it says shall have 1/3 of women. So meaning that
you want to refer to members to that?
Yes, Article 180 of the Constitution, 180
And
2B.
read the text.
And let me look for it in here. Article 180, Local Government Councils, Clause 1. A local government shall be based on a council which shall be the highest political authority within its area of jurisdiction and which shall have legislative and executive powers to be exercised in accordance with this Constitution. Clause 2. Parliament shall by law prescribe the composition, qualification, functions, and electoral procedures in respect of local government councils, except that a person elected as a district chairperson of a local government shall be a member of the council. B, 1/3 of the membership of each local government shall be reserved for women. That's where I want to stop. So, this the Constitution being the supreme law means that our proviso in the local government is a departure. We ought to have started by either amending the Constitution or maintained the status quo. This means that currently we have to maintain the status quo of whatever is provided by the Constitution. If we go by the amendment we created in the Local Government Act, whatever we shall do shall be challenged because it will be deemed unconstitutional. We are in the process. On Tuesday we had a special cabinet in which we presented a cabinet memoranda and the principles, and we agreed as cabinet to present a bill to repeal, to allow us present to cabinet the Local Government Amendment Bill 2020, by which we would revert to the original position of 1/3 being reserved as for women as members of the council. That is one. The other issue is in regard to age. The Constitution Amendment Bill 2018 amended the age limit, both the upper and the lower limit, reserving the age of 18 to be the age of majority. When we effected the Presidential Amendment Bill, we changed the age. When we effected the Local Government Amendment Bill, when we presented it to Parliament, we amended the age only in as far as the office of the chairperson LOC5 is concerned. We omitted to go lower to consider LOC3, sub-county, division, and municipal divisions. So, meaning that at section 111, if I'm not mistaken, section 111 of the Local Government Act, as it stands currently, still says that for one to qualify to be a chairperson of LOC3 should be at least 30 years. Now this is an amendment we ought to have done, which I consider.
You want to hold the fire?
You can.
The President of the Republic of
Or that you put it on record that for LC3 is
Yes,
30 years.
Yes, yeah. Thank you.
Below 75 years.
Okay, thank you. You have answered it.
Oh,
Now,
what are you thanking him for?
No, it's starting as done.
He's my senior colleague, so
So when he says sarcastically that that's very good law,
I
you thank him.
I let him
They
be.
know their
Oh,
language.
yes. He comes
I
from
think that is Lutoro now.
the chair. Honorable Kajala comes from Mwenge. And represents
You think he
Mwenge.
came directly from his constituency?
Influenced by the people.
He will have you.
No, but you see, when he drove through Chaka, he drove straight, not zigzag. Chair, so we ought to have effected this because we amended the constitution in as far as the upper and lower age limit is concerned. So
Okay.
our intention is to present the local government amendment bill to rectify that anomaly. Thank you very much.
Thank you. Members, Electoral Commission, anything you want to add on that?
Well, we are in the crossfire, Honorable Chair, because, thank you, Honorable Chair and members. We have been accused of denying some aspirants from getting nominated. On the issues you have raised, Honorable Chair, one on the issue of the names, may I give some brief background to that aspect, Honorable Chair and members. Now, before the coming into force of the Registration of Persons Act in 2015, the position with regard to change of names was governed by Section 12 of the Registration of Births and Deaths Act. The said section is 99% similar to the current Section 36 of the Registration of Persons Act, except for age. Whereas the Registration of Birth and Death Act provided, maybe let me read it first out in full.
Yes.
Change of name of adult, that's the subtitle or subheading. Any person being over the age of 21 years, or a widower, widow, divorced person, or a married person.
Excuse me, sir, which one are you reading? Section that, the old or
The old law. I'm giving the background.
Okay.
The background. Who wishes to change his or her name shall cause to be published in the Gazette a notice in the prescribed form of his or her intention to do so, not less than 7 days after the publication. And so now the other provisions regard the procedure. Now that section, honorable members, was transplanted almost wholly to the Registration of Persons Act, which is the current Section 36 of the Registration of Persons Act, with the exception of age. The age was lowered to 18 years. Okay? Now, that is the position. Honorable members, the courts have considered this aspect of change of names, and I wish to refer to the case of Taban, Idi Amin, Campo. This arose from the 2016 general elections. The petition arose from the 2016 general elections. I'll just give a brief summary. Honorable members, in that case, Taban, the respondent, the first respondent, that's Taban Idi Amin, was nominated. First of all, he was a registered voter as Taban Idi Amin Tampo. Those were his particulars on the National Voters Register. And he came to be nominated in those names. The academic documents he presented were in the names of Taban Idi Amin, without the name Tampo. But the NVR is Taban Idi Amin Tampo. Academic papers, Taban Idi Amin. His opponent, who lost to Taban Idi Amin in the general elections for that constituency in Kiva and the North constituency in Kiliandongo district, petitioned the court. The Court of Appeal agreed with the petitioner, and I think the petitioner was Otada. Yes, the court agreed with the petitioner, and the court said that the first respondent, that is Taban Idi Amin Tampo, was not a registered voter and therefore is not qualified for nomination and election as a member of parliament for Kivanda North Kiliandongo district. If he intended to adopt the name Idi Taban Amin Tampo, who was the registered voter, then he should have followed the requirements of Section 36 of the Registration of Persons Act. Now, that decision also referred to the Supreme Court case, earlier Supreme Court case of Serunjogi James, Mukivi versus Rule Uma Mawia. By then, the law had not yet been amended to make the Court of Appeal as the final court on election matters. By then, people could go up to the Supreme Court. The Supreme Court was reviewing the decision of the Court of Appeal in that matter, and it said the brief facts in that case were that the appellant, that is Serunjogi James, and the respondent, Rule Uma Mawia, contested as candidates for Member of Parliament for Kalungu East constituency in Masaka district. And the appellant, that is Serunjogi James, was declared winner. The appellant, Serunjogi, had registered himself as a voter in the names of Serunjogi James. He presented an A-level certificate which had the names Serunjogi SMJ. He presented an affidavit to explain the addition of the initials SMJ. The court found that for a person who is an adult to effect change of name, he or she has to comply with the provisions of Section 12 of the Births and Deaths Registration Act, Cap 309, which is in Parliamentary, which is the same as Section 36 of the Registration of Persons Act number 4 of 2015, save for variation of age from 21 years as required in Section 12 of Cap 309 to 18 years as required by the Registration of Persons Act. The Land Justice of Appeal concluded that there is no dispute that the appellant did not comply with the above provisions, and it goes without saying that he did not change his name legally. The attempt to do so through the affidavit was of no legal consequence. The decision ought to have been followed by the trial court as a binding precedent. So, honorable members, the commission is saying the law, the framers of the law, found it necessary even to include married women in this category, that if they wish to change their names, they have to follow this procedure. And the issue is not the commission entirely, honorable chair and members. It is the people who lose these elections, who go to challenge the winners, pointing out the disparities in those names. And the courts decide with the petitioners. And they even condemn the Electoral Commission for having nominated a person who presented the papers which were at variance, which had discrepancies, which were not tallying. So the commission came out and said, if we look at the law and the decisions of the court, it is imperative we caution and warn the aspirants that we shall not accept papers which are not properly harmonized legally. So that is the position we are coming from, Honorable Chair. Then on the issue of the controversies surrounding the councillors, directly elected women councillors, the Honorable Attorney General has put the position correctly. Again, it is the law. We are having a situation where Parliament amended the Local Government Act which was confirmed in conformity with the Constitution, Article 182 to 2B, but now it is creating a position, an elected position for every parish and every sub-county for directly elected women councillors. And in our guidance, we say no, insofar as that does not conform to the Constitution, it cannot be accepted by the Electoral Commission. We are therefore advising that the status quo, as provided for in the Constitution, shall prevail. Why? If we went ahead, honorable members, it's not that we have little regard or respect for the August House. No. But we are saying that if we went ahead and conducted elections on the basis of the amendment, which is directly opposite to the Constitution, somebody will just go to court and the court will definitely decide agreeing with him, and now whatever we have done at a very huge cost to the taxpayer, and also, first of all, in organizing the elections, and secondly, in the costs against the Commission. So we say, to be on the safe side, we stick to what the Constitution says. The same goes with the age for the LOC, the sub-county chairpersons, division, municipality, and so on. Whereas the spirit, our understanding was that the spirit behind amending the presidential age limit was also to cater for other elective positions. This was effected for the position of president, chairperson, LOC 5, or district chairperson. But I think by some inadvertent omission, it was not done for sub-county chairpersons. So the provision for chairpersons still remains as it was, that you have to be between 30 years of age and not above 75 years of age. So we have advised people accordingly, but again, this has drawn a lot of ire and disgruntlement, that how can the Commission do this? How can the president of the country be allowed to be 18 or above 75? The chairperson of the members of Parliament, they can be 18 or above 75. The chairperson of the district can be 18 or above, but not a sub-county. What wisdom is that? But then we said, we are going by what the law defines. Unfortunately for this one, it does not contradict any constitutional provision. Because if the amendment of the Constitution was the effect that all age limits, caps on elective positions are scrapped, then we would say consequentially this was also. But the age limit, the scrapping of age limit was for specific offices, specifically for the office of the president, or the position of the president, and specifically for the position of district chairperson.
May I interrupt you there?
Yes, Honorable Chair.
My lord, you're a judge. Which other office can be more elective than the office of the president? If an amendment is effected on the office of the president, why wouldn't the Local Government Act be used with the necessary modification? And the law allows that. Actually, the Local Government Act refers to the Parliamentary Elections Act, or where that is not captured, it goes to presidential. So why would you, I wish I knew those who are being turned away. You would still pay money. Yes, but I was the one interrupting when you did. I didn't know that I was giving a break for. Now he's going to conclude and hold the fight. Now the Attorney General, the former chair, they are all. You see, are you people not pretending that you are open? You are following the Constitution or the Local Government Act? In one, you are saying the Constitution is in the Local Government Act on women. The Constitution does not allow more than one child. when it comes to the age, you are saying the local government act is saying this. The constitution is silent on that. Madam Chairperson, what is the rationale? And actually, who is to blame? That bill came from government, assented to by, processed by this committee, assented to by the president. And they are changing the rules now. Okay. Chairman, I thought I wanted you to.
No, your predecessor.
No, I just thank you very much. Thank you very much, Honorable Chair. I think the relevant section on the matter you are raising is section 172
Of the Local Government Act,
which says, if I may read, for any issue not provided for under this act,
100 what?
for any issue not provided for under this act, the Presidential Elections Act and Parliamentary Elections Act in force shall apply to the elections of local councils with such modifications as may be deemed necessary by the Electoral Commission.
Wouldn't you say hallelujah?
But that is qualified. Something not provided for. This already provided
But
for
this one is-
under 211, under 101, section 101.
Can you make it case? So that's the challenge.
111.
Yes, 111.
I would like to hear.
The point I'm making, Honorable Chair, is that the age, qualification age for a chairperson of a local council, 3, is specifically provided for under this act. And therefore, you wouldn't apply 172, which is permissive, to bring the matter of age, to lower the age limit for a chairperson of a local council, 3.
You would.
Wow.
You know why?
Why?
The principle for the Presidential Elections Act to be at 35 was equally borrowed for the local council 5. Now, that affected also LC3. People wanted the people with the level to be the chairperson of LC3.
That was specifically provided
Yes,
for.
I would think you would.
Honorable Chair,
Yes.
if you look at, just to supplement on what Commissioner Tashovia says, if you look at the age for the district chairperson, it was not derived from the amendment to the presidential age limit. It was specifically amended. The age for the district chairperson was specifically amended. And therefore it follows that even for LC3 or sub-county, there should have been a similar amendment. But insofar as it was not done, Section 172 provides for those instances which may not appear in the Local Government Act, but which appear in the Parliamentary Presidential Elections Act as far as elections are concerned. But when it comes to a matter that is already provided, for example, the age for chairperson LC3 or sub-county is already provided for.
Yes.
So therefore,
When do we apply amendment by infection?
When there is no specific provision.
when there is no
When there is
specific
no-
provision.
What happens when there is a specific provision on the presidential, then for LC5,
Yes.
when do we harmonize this?
Does it just
Yes,
follow?
Honorable Awasal.
Thank you very much, Mr. Chairman. Mr. Chairman, I want to agree with the position by the Electoral Commission on this particular matter. Only this matter. And I will explain why. Mr. Chairman, I think there was a grave omission
On which part?
on the part of government and on the part of Parliament. The application, the mutatis mutandis principle that we are talking about can only apply when there is no specific provision. With due respect, the constitutional amendment bill that sought to remove the age was very particular. It did apply to the president. It did apply to the LC5 chairperson. When you look at the Local Governments Act, specifically Section 111, subsection 4, it is very clear. It makes a provision for age of the chairperson of a municipality, town division, or sub-county. It is very specific. So, what should have happened, Mr. Chairman, was for government, if the spirit was to remove the age limit for this particular office, they should have brought a bill to amend Section 111, specifically subsection 4, paragraph C, to remove the age limit. That did not happen. Now, if the Electoral Commission is acting to keep away people who are not 30 years and above, with due respect, they are right. They are following the law. What should we be doing at this point in time? Government should be moving very fast. I think you have gazetted there is a gazetted bill, isn't it, for local government? Include this very immediately. Meanwhile, the Electoral Commission should defer. No, let me land. Otherwise, you are going to create a fracas in the country. A very big fracas. Because the issue of nomination dates is not legal. It's something you can reverse in a gazette to avoid this fracas. And really, we are not blaming you, no. So this is a matter that can be, the nomination of these candidates can be deferred until already the Speaker, Mr. Chairman, the Speaker has goodwill in as far as these amendments are concerned. It can be deferred and then this matter be addressed urgently. Mr. Chairman, that is my first aspect on this matter.
Maybe just to add to what Honorable Sali was saying, now that is on our side.
I know why.
So it's on the side of the law.
He's surviving on interim order.
I just wanted to volunteer.
But not by
I just
this.
wanted to give information. Honorable Sali, I just want to give information. Honorable Chair, sorry.
Yes,
that the nominations for local government are going out on up to 1st of October. So if government moves fast, there's still ample time. 1st of October is Thursday next week.
Very good information. Secondly, Mr. Chairman, on the issue of again the issue of Athad, this discussion was in Parliament yesterday. Again, really, we must be sympathetic to the EC, where the Constitution talks about a third of the councils, and it's in the Constitution. If the Constitution has not been amended, what shortcut do we have? There is no shortcut.
I think
Finally,
less on the age. Since the election, the nomination. Is that the president calling? Tell him I'm sharing a meeting. So you can imagine a call that removes the leader of the delegation. But since it is spread out, there should be hope. And as I'm being given information here by our technical people, that actually that formed part of the amendment. Something went wrong
Somewhere.
between here and the signature table. And when we were processing that, people were obsessed with the qualification. I think the qualification prescribed in the plenary killed. So, and then we could have gone back to the original bill. So it's something that can be corrected in the plenary here, with this bill which is coming up. Yeah, can be corrected. But what could give hope to the 18-year-old in 1 second who wants to contest for LC3, say don't commit suicide. There is still hope. To me, as long as we harmonize that, then the case for those who would feel they should be treated the same, should put me at peace with the Electoral Commission. And you are your government. You are an agent of government.
Honorable Chair, we did write to the Office of the Attorney General, Minister of Justice, I don't recall, pointing out these anomalies. We did.
They never pointed out here also in the plenary. This should have been anyway. We were there processing that, yes.
Let me conclude on the issue of names.
Yes.
Mr. Chairman, on the issue of names, there is nothing new in the law. The impression being created is that there is anything new about the law. My Lord, as you have rightly stated, the Births and Deaths Registration Act, I think it was Cap 309, which was repealed by the Registration of Persons Act. That particular provision on change of names, as you have said, is actually you say the 90%, but it's 99%. Because save for the issue of age, and that had to be amended to reflect the Constitution, the age of majority. Now, you must distinguish two things. One is the issue of changing of names and the issue of clarification in the errors of names. Those two things are very different. When you look at the Supreme Court decision of Serunjoji Muchibi, while agreeing with the Court of Appeal, they were saying that Serunjoji Muchibi, by adding the initial SMJ, that constituted the change of name. And that person had to follow the procedure. Now, there are instances where there are errors in names. Instead of writing Vasalirwa, you write Vasaliza. Okay? And so you get a statutory...
But they mean the same anyway.
Yes, you get a statutory declaration to clarify that there was an error either by UNEP or so and so that occasioned the difference. Now, that is not a change in name. Now, a change of name happens where there is an addition or a subtraction or a complete overhaul. Now, each time when that happens, my Lord, according to the Supreme Court, that constitutes a change in name. And what that means in law, my Lord, is that somebody must make a notification in the Gazette. And that notification is in the regulations. The regulations are in the old law. They were preserved. These ones by NIRA have nothing to do with changing names. The regulations, they are cited. But the other ones under the old law are preserved. So you have to make that notification, take it into the Gazette. Now, the issue of notification, sometimes people make deed polls and take in newspapers. The process is not completed by going in the newspapers. It is not. It is an error that I know some of my professional colleagues make. It is not completed by going in newspapers. The process is completed by going in the Gazette. So whether you make, because in the law there is nothing like a deed poll.
Honorable Ambassador, I appreciate that. Can we agree here? If a woman X gets married to Y and he adopts the name Kajara, they say it's Jovan or Jovra Kajara. Does that constitute change of name?
Yes.
That's the question we need to answer.
Mr. Chairman, and that's what I was coming to.
Yes.
Because the learned Deputy Attorney General yesterday on the floor was trying to make a statement that you can use a statutory declaration to explain that. But when you read the, oh, maybe I got you wrong.
He said that is the old regime, legal regime.
Okay, but you see there is no old and new. As I said, there is no old and new legal regime. The law on change of names has been similar for a long time. Now, if somebody adopts the name of a spouse...
You first help this committee, as you are now a witness. When a woman adopts the husband's name,
yes.
Does that constitute a change of name or not? If we agree on that principle,
Mr.
we can
Chairman,
move.
according to the Supreme Court decision, of Muchibi Serunjoji versus Lulema Wia. That constitutes a change of name.
Now you are brilliant. Okay.
Okay. and in effect, that change must be gazetted.
Okay.
And unless the Electoral Commission receives a gazetted, the gazette, there will be a very big problem. I know that there has been laxity, even on the part of the Electoral Commission. People present to you affidavits, they present to you statutory declarations, and you are nominated to repeat it. Now, the other problem, Mr. Chairman, as I conclude on this matter, is that the courts have not been helpful either. The Court of Appeal has conflicting positions on that matter. Very conflicting positions. And I have had a problem with them. Because when I was arguing the Namuju Sise case, I was quoting a Supreme Court decision. Now, the Court of Appeal disagreed with the Supreme Court. Typical Lord Denning style.
Is that in Uganda?
Yes, the Court of Appeal disagreed with the Supreme Court because Namuju has Donozia Gusaba on one of the documents. Then the other documents, she has Sise, Namuju, Dinyozio. And when I quoted the Supreme Court decision, those two were completely different. The Court of Appeal disagreed with me. Now, in another decisions, the Court of Appeal has said, if there are differences in names, then you must prove that the owner of those documents in the other names exists.
That's even and
Total confusion.
Yeah.
So I really think, my Lord, that going forward, this is a matter where we could seek the guidance of the courts by way of a case stated, because there are conflicting decisions. Because I have heard you quote the case of Otada. Even the learned Deputy General on the floor was quoting Otada. But you now need to read very extensively because the issue of change of names has a lot of jurisprudence. Which case are you going to rely on? And we must be very careful in as far as that matter is concerned. I thank you, Mr. Chairman, for giving me the
That is unusual to give you all that 10 minutes, as if you are the guest of honor. Yes.
Yes. You can hit. You can hit.
No, but you were.
Yeah.
Chair, can you project?
Please, order. Kalungu. Before we proceed, let me have members who have not introduced themselves to introduce. I think that's why we are having this Mama. We shall make sure we are about to come to a conclusion of this matter. On change of name, we will conclude it on the 8th. The 8th issue is a mistake, and the Attorney General was just shy to admit.
Mr. Chairman.
Just
allow me a second.
Yes.
You can present this bill.
That's why when you were out, we resolved it.
And this is the old bill.
Okay. You introduce yourself once and then what about
Mr. Chairman.
introduce yourself. I'm not giving you to speak. I have already finished
I'm on Joseph Mr. Chairman.
Okay.
Kalungu County West.
Then,
Thank you.
why are you holding the chin like your grandmother died?
No, we are not using that.
You make me very sympathetic. Am I looking pathetic? Okay. So I'm coming this side. Yes.
Thank you very much, Chair, and the Attorney General and the Chair of Electoral Commission. I want to concentrate more on the change of name. Although under women councillors, I had a chat with the Attorney General yesterday, and I told him that 1/3 is minimum.
Yes.
And we should not lie on the minimum to make a case. So my second point is on the change.
Because you are setting a principle. The question under Article 182B, is it setting a minimum or a maximum?
Minimum.
Honorable Chair, I've made my point on that one. Other people will develop on it.
You need to concede if you did.
No, we had a personal discussion. Don't force him to concede. He will talk. Secondly, mine is on the change of name. I'm one of the people affected, and I need to be guided here on this table to make a decision. I went to school normally, and I finished all my studies by 19...
What do you mean normally?
Under what names?
Under the name of Veronica Isala Eragu. I had nothing to do with a man in my life when I was studying. When I finished studies, in 1980, I get married to Bichetero, the lucky man. No, Mr. Bichetero. I beg your pardon. And I don't, Chair, I need total attention.
That's why you have to know nothing to do with men when you're studying.
Yes. I get married in 1980 to Mr. Bichetero. Immediately, using my marriage certificate, which was evidence at that time, and all the witnesses who were at that wedding in Sheraton, I changed my name to Bichetero. No, it was still, it was Apollo Hotel. Now, I have been carrying on and carrying this name Bichetero, and nobody disturbed me. Even when I came to nominate for Parliament in 2015, all I had to do was to do a declaration explaining the circumstances where Bichetero comes from. And I attached a marriage certificate. I was duly nominated by the Electoral Commission that is still alive in 2015. Today, I consider that if I interpret this law the way they are talking about it, when I come in before 26th of March, I should be safe. 2015, I should be safe. And 2 weeks ago, I went ahead and prepared all my nomination documents, again, using that statutory declaration to say, this is how Bichetero comes. All my academic documents are Veronica Isala Eragu. My identity card, which came after I finished all my work, is Veronica Isala Eragu Bichetero. All the 4 names.
He's getting a man.
I got now.
He's getting a man's name, right?
Thank you. Now, if I'm to be denied nomination because I happen to adopt Bichetero's name, can I ditch the man? 2, why would how does this affect me? I'm being selfish. I want an answer for my case. Everything happened before 26 March. I have a declaration and an affidavit to prove. And even recently, 2 weeks ago, I still did another declaration, to support the papers I'm about to bring to you.
Actually, if you had them, you would do that.
I will hand them. In fact, I'm following him to his office. Now, am I going to be condemned to go and participate on this because all I see in this one, and when you were reading, I was attentive, The only thing that changed is 18 years instead of 21 years. So for my selfish position, can I know, will I nominate? Must I go for the gazetting? And if I'm to go for the gazetting, what crime have I committed to go for this gazetting other than marrying Bichetero?
Yes. Honorable Nani was first before you, but I think you.
Chair, I just wanted to add to my sister here. Nominations, the process of nomination is going on
For local government.
for local governments, and it applies to them as well. Today is the 24th of September, and the deadline for nomination, I think, picking papers is 1st October, 1 week. And it takes approximately 3 up to 4 weeks to have this process of the deed poll gazetted. You imagine people from up there in Kabong, they don't know, they cannot interpret some of these things. People in Kisoro, people in Kanungu, Bundibujo, Bulisa, Koboko,
About Bugwe.
all these areas, language of deed poll, the language of gazetting is actually foreign to them. So what is the Electoral Commission going to do to ensure that these people are not closed out? Well knowing that you had a lot of time, the electoral process started a long time ago, you don't wait until at the tail end of the process to start blocking people for reasons that were not of their own making. I know that ignorance of the law is no defense.
Yes, I think you're coming to this. You had made a wonderful point. And even when you say ignorance of the law, you now answered your own thing. Electoral Commission, the point you had put is that in view of the ongoing,
Yes.
that now it is a concern.
Yeah.
What can Electoral Commission do so that justice is dispensed?
Chair, you have just read my mind and made my conclusion. Is it possible that government or even the Electoral Commission can quicken this process on behalf of those people coming to be nominated by having notices, by having papers ready with the Gazette and so on, so that you can assist these people really catch up with the process? Otherwise, it will be a disservice to this country. It will be a disservice to this country if you closed out these people.
That's a way forward.
Thank you.
Thank you, Honorable Chair. I want to comment on the third for women councillors, the 1/3, and really to echo what Honorable Veronica has already said, that this was the minimum. Because we have to be able to read the meaning or the intention behind the law. And when you read the entire constitution, you find that the third was minimum. And I don't know why we want to take this simplistic interpretation and want to hold to disadvantage women and say that we must remain with a third, when we know that the third was a minimum, and that these women, we have already given them hope that they can represent one sub-county per woman. The minister said that they are preparing a bill to revert to the original position. Is it not possible to have a constitution amendment bill? And because we have processed some, for example, who is this man from Igara?
Age limit.
We have processed a few of these bills quickly in a week or two. Is it not possible to have a constitution amendment bill regarding this to reaffirm, because it is for the good of all Ugandans? I think it can be done. Then on the change of names, my academic documents bear Jova Kamateka. I got married, and as the registered voter, I am Jova Kamateka Karamagi. I hold my card here. Yes, Jova Kamateka Karamagi.
And you are the same
When it
person.
came, and I'm the same person. So when it came to representing the people of Mitoma, I chose that I would represent them as Jova Kamateka. So now, according to your requirements now, must I be Jova Kamateka Karamagi? Must I be nominated as Jova Kamateka Karamagi? I did swear an affidavit in 2010 to say that I'm the same person, but I chose to represent the people of Mitoma as Jova Kamateka. So, what do you want us to do?
Please, I hope you're not in the question.
Yes, because now you are saying that if I have change of name and I swear an affidavit and present all these papers, then I must remain Jova Kamateka Karamagi.
I think you've made a point on that. And
Thank you very much. Thank you very much. And as Kajara, Honorable Kajara said, people need to know, because you are creating a confusion all over. Thank you very much.
let's not accuse the electoral commission. We shouldn't.
To do the right
They are
thing
doing
is a
their
long
work.
standard.
Nobody is confusing.
No, but we must have a choice. We must leave choice to people.
Honorable President, I'm coming to you. You will meet us. So be patient. Hold not, and you're a lawyer and a teacher this day.
Maybe finally, Honorable Chair.
Okay.
Yes, if I have an affidavit that was sworn in 2010, must I swear again for
They
this
will
time?
provide us the guidance. Yes. Fukweli MP, woman MP, and also the...
No, I want to ask you.
Since women are talking.
I'm acting woman MP. I'm not a woman MP.
Thank you for your correction.
Sorry, Mr. Chairman, I came in late. And the risk you stand when you walk in a meeting late is to be repetitive or seek an explanation on a matter that has already been settled. I am certainly conscious of that. But listening to colleagues, since I walked in this room, talk about discussing form and not substance is what we are doing. Is the problem with the Electoral Commission? Absolutely not. The problem is with us raising it, because we enacted the law and provided for it. We provided for those technicalities, even when they actually don't mean sense. Because when you look at the Constitution, Article 126, it is very clear that even courts of law are enjoined when they are dispensing justice to give undue regard to technicalities. And now we are here giving technicalities regard. Why? Because we created it. Is she Jovia Kamate Karamaji?
Is she Jova Kamateka?
Or is she Jova Kamate? Why should anybody use a law really to be creating a debate that actually doesn't reflect justice? But we created it. It is the law as it is. What are the solutions to the challenge we are having? It rests with gentleman number one facing us. This is your baby. If you realize there is a problem, a crisis, move an amendment and you sort out this crisis. It is as easy as that. Just Biabakama has nothing to do with this. She just wants to apply the law as it is. The day you expect them to bend the law for convenience, I am telling you, we will be setting a dangerous precedent. Because tomorrow, he's going to use that precedent to bend another law for convenience. And the attacker will certainly be our side again. So, Mr. Chairman, it is my very humble prayer that we have realized there is a challenge. There is a challenge of form as against substance. Why can't the Attorney General and ourselves move to amend the law such that you don't have this challenge? If that happens, we will not even be having the entire Electoral Commission and us here.
Mr. Chairman, I want to thank you very much. And first of all, Mr. Chairman, still with amendments, when you look at Article 183 of the Constitution, it has the clawbacks still. Because when you say that the person is not qualified to be elected to be a person unless he or she is qualified to be elected member of Parliament. We have members of Parliament that are age of 18, meaning that that person can be, but I don't want to go into depth of that. So kindly, Mr. Chairman, you still have to revisit this and correct all these clawbacks. Now, Mr. Chairman, Honorable Abdul Katuntu, my senior, as stated, is very correct. Let me say this. When you go to Gazette, an LC3 chairman who has discrepancies in his names, let us leave the marriage and what, but there are discrepancies. Gazetting alone requires him to pay 300,000. Now, 300,000, this person is going to earn 250,000 per month.
You want to put on your mask properly? It's not a cheap mask. Put it properly.
Mr. Chairman, I was building on Okatuntu's behavior so that my voice can come out. So,
No, please follow only the law.
Only the law. So, I because even in the commission's statement, there are a lot of discrepancies and contradictions. When Honorable Kamateka and Honorable, now I want the other Christian name, Veronica, state that we all have similar problems. Because we have been making statutory declarations, Honorable Abakama knows it as a Catholic, that we have a lot of names on our baptismal cards. And our names were changed when we went to school because they could not fit within the indexes and what have you. So, Sewungu is Sewungu Joseph Gonzaga. Now, one of the non-performing areas in correction of mistakes is in NIRA. Many people have their names that were wrongly written on their identification Nangamuntu. And correcting that is so difficult, and I don't know whether many have achieved that. So either Parliament, as Honorable was stated, let us go back and make the amendments as fast as possible, so that we avoid this cost for Ugandans, as people from Kabong, far from Karamoja, they cannot come to Kampala to make gazettes and what have you.
You made a very good point on the way forward.
That's the way forward. Lastly, am I allowed, because I'm not a member of the committee, Mr. Chairman, there's another issue I wanted to raise so the chairman can respond to it before we leave. I don't know whether I'm allowed. Mr. Chairman, we have this in the general public domain. I'm a member of the National Unity Platform. And the recent Electoral Commission was asked by NUP.
You left the DP?
Yeah, it is not in news. It is not in news now. Mr. Chairman, Mr. Mabilis demanded for the documents of our presidential aspirant candidate, that is Bobby Wine. And the chairman of the Electoral Commission gave him every qualification and documents of Bobby Wine, and he based on the laws he had to follow to give him those qualifications. When we asked for the same for Mr. Museveni, Kaguta, still the Electoral Commission refused to give us those documents to look at them. But they never cited any law that was used. May I know why the selective...
Okay.
Did you pay? Did you pay?
Definitely. Once he quoted the laws, payment must have taken place. No. You see, I'm sitting near paralegal. So, search fees and everything. So we want to know where is the discrimination and operation.
Okay.
If you handed in...
You've made a point. The landed chairperson is a judge. Understands very quickly.
The land is secundum.
Yes.
If I told you went to the seminary. Thank you very much.
Oh yes. Please, can we we want to, because with this, the discussion has generated a lot of way forward, which we need to. One, the main thing here, Attorney General, Article 182B, you want to stop there. What about D, 2D? How does Parliament review the composition? Because Article 182D says Parliament shall review after 10 years, after every 5 years, like we did recently for parliamentary older persons. We reviewed the composition of the council. So, at what form does it take for Parliament to review the composition of the council with relation to Article 78? The moment you are conveniently, you see, you don't even need to amend the Constitution. If the review is by amending the Constitution, you tell us. But Article 182D gives mandate a very wide latitude with a wide interpretation to do, for Parliament to do what it did. That we can change, and actually the Local Government Act has been amended before. And reflecting, here a piece here is section what? Section 23. Was amended before. You know, we passed an amendment we passed an amendment here, the Amendment Act 17 of 220. So, the mandate of Parliament, 1/3, and we are saying 1/3 is not enough. Why I support the women, the Attorney General, and I gave you notice that if you bring that amendment, the reason we are having all these problems, we are not involving the Minister of Local Government. It's a Local Government Act. We are not involving the Minister of Local Government because these are electoral matters. But the actual budgeting, even when the chairman, these people of Kaviramaido, you want to eat peanuts from here?
Yes, sir.
The actual budgeting, when you look at gender mainstreaming, look at how we fail to impact our societies. Because one woman represents 3 sub-counties. When it comes to budgeting, their voices at the district council is very minimum, 1/3. At Parliament here, when they bring a district budget, for Toronto is 30 billion. We just pass without any. I will know. I'm the chairman. At the end, I will know whether they were hearing me or not. I will exercise my Article 78 of the Constitution. You did that, and you were in Parliament to review the composition. The Minister of Justice moved, and then we brought the elderly. Of all the people in Uganda, we brought the elderly. Now we are talking about the women, active women in the community, and we want to rush to amend the law to lock them out. What are you talking about? Respond.
Thank you very much.
You like women.
You know why.
Thank you very much. You saw me comparing with
I referred to. Yes, you are giving me attention.
I've been comparing with his lordship here. We do understand that the review referred to in B is exactly what we undertook in reference to the elderly. We can only, special interest.
This is referred to earlier in 32.
Unless if this committee guides that the previous amendment we effected in the local government was intended to be a review, then we can agree on whether or not to carry it forward that way.
It's not just that's what we did. We talked the background to that debate. I was in the house.
I'm trying to answer specifically to that.
Okay.
And I repeat, unless this committee guides that the amendment that we brought to Parliament in respect of the representation of women was intended to be a review envisaged under Article 78, then so be it.
This is the composition of women council.
That's why I'm saying, unless this committee guides.
You want to invite.
But in the event that there is no such a guidance.
Your Honorable Katundu wants to give you an opinion.
Yes.
First of all, I'll be surprised if the Land Attorney General says.
What happened to your mask? We just learn to listen to each other when we have masks. Yes.
Up to the nose.
Perfect, sir.
First of all, I'm really surprised that the Land Attorney General, who by Constitution is the principal legal advisor to all of us on legal issues, is asking for guidance on this legal issue.
He's being polite.
That's number one. But that said, or looking at literally, what he was saying is that actually what we did in Parliament was never envisaged to have been done under a review, the constitutional review. So that is purely management. We cannot try to do what you call legal engineering. That amendment was done for a purpose. It was done, brought under provision, some provision of the law, not when we are exercising our duties and powers under Article 78. So that can arise in the Land Attorney General.
But in the event that you find the review that, of course, the review has to be moved by the minister.
It comes from you.
Now, when this amendment was made and supported, including by the minister, we were all in the house. And you remember, that was a bill before this committee. When it came, the Attorney General, Deputy, Minister of Justice, they were all there clapping for the bill to go through. Because the women, the Owopa, they moved. They made a very appealing case, just like I tried. So, you see, I don't think whether the government knew Article 182D. If you knew it, you would not be proposing for amendment. You would only come to Parliament for ceremonial statement, said we want to thank Parliament and the people of Uganda. Now that the composition of women has been reviewed under this, you make some ceremonial speech to cover your back, and we shall stamp our feet.
Allow me to cut you short.
Thank you. I'm too tall. Go ahead, sir.
I will seek that you allow my ministry to confer with that of local government and the electoral commission.
Where is Honorable Majes, the wisest man in local government?
And maybe we can appear on Tuesday morning and give you our position.
We are going to report tonight.
On this?
Yes.
This particular one of women.
And that is the main one.
Yeah.
You will report that.
And I have to remind you, the presiding officer
is a woman.
And the Attorney General is a product of a woman. The chairperson of the committee, I have never felt so passionate like I am for this bill. In fact, if you bring that bill to show that I will oppose it, I will not share the session. I can tell you, my conscience will be conflicting.
Okay. We shall confer. Chair.
And
we
you'll
shall
be sure I
with
will try to mobilize with all the resources I have against that bill.
We shall confer with our colleague in local government.
Mr. Chairman,
And
as the Landed Attorney General goes to think about this, I would like to draw his attention that the process of an election does not start with activities of electoral commissions. That's why they issued a roadmap and guided even political parties to set in motion their internal processes.
That's right.
Now, as we go on changing the laws, what happens to the processes of the internal process that have already been not set in motion, actually ended? They already finished. For example, there are candidates who were not qualified in the primaries of the parties, and they were locked out, and the parties have closed their primaries. So now when they open up, what happened? So as you go to think about it, please.
Honorable Katuntu, I'm glad you brought that up. I also want to bring to your attention the fact that this matter might also have financial implications. We do not know whether the Minister of Finance had considered it and given a clear go ahead, or if not considered it, and that is the reason why
since when did the government start crying for financial?
No. What I'm saying is that there are matters to be considered before we come forward.
Yes.
The government that brought up this bill to Parliament when we passed that every sub-county should be represented by a woman.
They knew the cost.
I agree with you.
Must have been sure
Since
of the
when has
funding.
government started
So the funding can't have
crying?
changed.
But you see, the fact that the Electoral Commission is nominating on the old regime
You see,
means that the finance has to be considered.
Order, it is not late. One person from Bugiri, called as Man Basadra, MP, he said the issue of nomination is not a legal, it's not cast in stone. I know in my area of women who had picked for each sub-county in the NRM primaries, and they were locked out. The moment you open it up, they will just go.
So you have another primary. Open up primaries again.
You see,
for political parties.
but what we need to know, the other one they had already campaigned. They were so different. They even elected. Yes. Order.
Thank you very much, Chair.
You have two machigas sitting next to each other there. Will I handle? Proceed. The two machigas there. Yes.
Thank you very much, Chair. Through the Attorney General and Chairman here. As soon as the Honorable says, the activities in the roadmap of the Electoral Commission, they run into each other. As one activity is concluded, another one is also handled. And of course, as members know, the role cannot work. And I think that's why the Attorney General was saying, let's go the Attorney General's office and ourselves as the Local Government Act. We are aware the roadmap is not cast in stone, but it reaches a point where you cannot do some things even when they are not covered in the law. I think that can be done after our consultations. We'll get back to you. But that cannot be effected now. It cannot be effected because of the things that have to be done at particular times.
Honorable Chair. Honorable Chair.
Yes.
Surely, if a mistake has been done, if an error has been committed, it would be more noble to correct that error rather than insist on the processes that have already taken place, knowing very well that it is not too late. People have not been nominated. No, it is an error. It is an error, and that error can be corrected for the good of the people of Uganda.
Here comes the only minister of local government in Uganda, Honorable Parliamentary. Local government. Honorable members, I have a case. Honorable members strictly asked by bringing the age limit. And we are suffering interviews for him. He said, I'm not going to come. And his home and cried. You are really
Feeling with pleasure.
But we are happy to see you here. I've been talking, your colleague said, we are on local government. And we thought that every time we have a local government, we should be here. This was impromptu.
Of course, you give them.
Let's bring him on board. Let him settle down. So, Honorable Minister, the Attorney General, when you are here, you are the Minister of Local Government, of course, but the Deputy Attorney General, I find it difficult to refer to you as a deputy when you are actually representing the two offices. You are a full minister here now, and you are Attorney General. So I don't want to refer to you as Deputy Attorney General. No, you are too generous. So basically, the issue of women cancer.
Having stated the position,
the minister here, one time they disagreed in our committee by abusing, not wrongly, which one now? You have a commissioner who is setting over my... now that I'm going to be in your hands, sir, what can I say? Yes, so basically the issue of local government. The electoral reforms came as local government. Local Government Act amendment came as electoral reforms. But it's raising a lot of things. Your colleagues left you behind. And back and forth. I'm glad the Deputy Attorney General called you. This meeting was directed by the House on short notice. I'm glad that you are here, whereas we are concluding. You found the Honorable Deputy Attorney General had referred to Article 182B, which specifically says, except 2B, to say 1/3 will be reserved for the women. But 2D says the composition of the council and their functions shall be subject, as just we do under 78 for the Parliament, will be subject to review. Now, you see, earlier on, C, 2C, refers to Article 32. Groups, the special interest groups, we just did successfully for the elderly. And how I wish the elderly were saved from campaigning. I had to see the videos online of retired bishops, of retired civil servants campaigning. They should have been honored as elders to be picked by me, the chairman of the legal committee. When shall you give me work? So, the jokes aside by Honorable Katuntu, the issue is that some of us here have very strong view that what Parliament did not contravene any constitutional provision. That that issue of we are actually giving effect to constitutional provision, because gender mainstreaming, budgeting, you also know how these people struggle. The women are 1/3 only, 1/3. When they are budgeting on matters that relates to women, no wonder 16 women die every one, whatever now, as they give birth, every day. Because men do die, but at least the women, men never die when they are giving birth, if they are supposed to. In the process of production, they don't die. The women die. So, if we can empower women and have more women and get involved at the district, that was the genesis of this debate. The budget for women-related things, maternity, whatever, because really, yeah, that's my plea. So if the law can be modified, harmonized, synchronized, on the age for LC3s, we've considered it was a mistake that I think even this committee should own up on the mistake. We should have been more cautious not to allow that. I think the proposal of 4C in 111, 4C, was the government proposed to delete. I do not know how it was not deleted. So I do not know how we did not process that. And JP, you were in the house, the Attorney General, you were in the house. I was there. I was the chair, I think. Huh? Yes, I was the chair, but my vice processed the local government, but I was in the house. We have to own up this as a problem. Even this committee, yeah. So, Attorney General, Minister of Local Government, you are the only wise man who has finally come. You bring motion for age limit, you did not bring for LC3. And now you didn't know that the LC3s, you are going to be their boss. I wish they could come for you. Yes.
Something.
Why didn't you make the age to remove it from all elective positions? I tried to be mechanical in the reasoning here that the president's office is elective. But they say it had to be specific. Yes. So we are waiting for your statement. And your colleague was saying he wants time to harmonize with you so that we can agree. Yeah.
Thank you, Chair. Good afternoon, honorable colleagues. Glad to find Honorable Deputy Attorney General here. It is true that the other day I requested him to stand in for me in Cabinet, present the bill, which he did, and I thank him for that. But reminds me of a man you called and you said, help me to take the fees of my children to school. And when you come back in the evening, you find him in the bedroom looking also for the school fees. The man has even gone to the committee to represent me without telling me. But we mean well. There are two issues, Honorable Chair. The first issue is the issue of age limit. The proposal we brought and the bill we brought that time was an amendment of the Constitution. And in the Constitution, we had those two offices, the office of the President and the office of the district chairperson. The age limit for the lower local governments is not in the Constitution, it is in the Local Governments Act. So, in bringing my bill, Chair, that was a bill for amendment of the Constitution. The assumption was that the government would proceed to amend the other laws. So now it's coming to the law called the Local Government Act. I think it's only fair and just to also amend the Local Governments Act to remove age limit for the chairpersons of the sub-counties, the town councils, the divisions, and the municipalities. so long as one has the basic requirements to be a voter. For me, I think that one is straight. The second one is the one of the women councillors' representation. Mr. Chairman, it sounds small, but it is a very serious matter. We sat as Parliament, we amended the Local Governments Act, and we provided for a woman councillor per sub-county and town council at the district. And similarly per parish or ward at the sub-county or town council. I totally subscribe to the philosophy of gender empowerment, ensuring that we have enough representation of the gender. But I think the limitation is completely under the Constitution. And the Constitution does not use vague words. It is very clear. 1/3 of the membership of each local government council shall be reserved for women. There are two reasons, Mr. Chairman, there are two clear words there, which we need to bear in mind. The word shall is mandatory, and the other word is reserved.
I think you start from the word except.
In that, the Constitution is here. I don't see the word except under B.
It is there.
The law shall prescribe the composition qualifications in respect of local government councils.
Yes,
except, let me read it, 182. Parliament shall, by law, prescribe the composition, qualifications, functions, and electoral procedures in respect of local governments, except that is an exception. You shall not tamper with that one. 1/3 of the membership.
Where are you getting the word shall not tamper with
except, it's an exception.
That is your interpretation. Go ahead.
So, I was saying the word reserved. Let's go into figures.
It's a directive.
Colleagues, much as we may, we're looking at the problem of one woman councillor representing 2-3 sub-counties. It is an uphill task. It is a big constituency. But let me give you the figures. Suppose the district had 20 sub-counties. The minute you say one sub-county is represented by a woman,
yes,
because that position cannot be competed for by a man. That is reserved. So that means you'll get 20 women councillors. Now, the other constituencies, the 20 sub-counties, the women will also compete. Agreed? Now, if you get your pen, you have 20 reserved for women councillors. You have the 20 directly elected. Then you have the special interest groups. The special interest groups, you're talking of the persons with disability, the elderly, the youth, and who else? The workers. Those are 4. Times 2, those are 8. Colleagues, I want us to go into the mathematics of this. So you have 20, which have been reserved for the women councillors. Out of 20 plus 20 plus 8, a council of 48. 20 divided by 48, you have not reserved 1/3. It is much more than 1/3. You can take a council of any other number, whether there are 10 sub-counties or 30 sub-counties, you will get into the same scenario. The point I'm making, the Constitution makes what we call a reservation. Don't go below this. Below this, then you are unconstitutional. You can get a third plus.
Yes.
In order to get that 1/3, the Electoral Commission must look at, remember the constituencies we gave the Electoral Commission. For example, the women members of Parliament. If the law was changed to say, in every constituency, there shall be a woman MP, you will no longer be on the 1/3 minimum. Because then you will provide the 353 plus the directly elected, it will go beyond. My point is, in order to observe the constitutional mandate of reserving the 1/3, which does not mean you cannot get more than 1/3, no. We're saying what the Constitution says, reserve as mandatory, as a must, 1/3. Electoral Commission has been putting one councillor of a woman representing 2 or 3 nearby sub-counties, but they have that requirement. They must make sure that that reservation is not less than 1/3. Now, the chairman of the Electoral Commission called me and said, but Mr. Minister, we are obliged to follow the law Governments Act, but there is a law above that, which is the Constitution. And he clearly said the Constitution on their number reserved for Parliament, for women councillors, councillors at all levels, sub-county, town council, is 1/3. What you have done in changing that, you have lifted that bar beyond 1/3. So we presented this to Cabinet. Cabinet has understood, and we think we need to bring it back here. Actually, the Electoral Commission has gone ahead. For them, they are saying they are implementing the Constitution until we, Local Governments Act, also conform to the Constitution. It is the higher law. So we are appealing to Parliament. We are not against women emancipation, including increasing their numbers. But if we want to increase their numbers beyond 1/3, we start with the Constitution, honorable colleagues. If we want to say no, let there be a woman councillor per sub-county, then we start with the Constitution. But as long as we have the Constitution, which was not amended, my plea is let us observe the status quo. So long as we empower the women, they secure their 1/3, they compete even in the directly elected councillors, they get even more than 1/3. We have some councils where we have 40, 50%. But we have to observe the Constitution. I thank you, Mr. Chairman.
Yes, I do not know. You see that sharing a meeting where you have interest is very difficult, and you don't know how to hide.
You understand as a woman councillor?
Now, can you imagine? You hear what the chairman, the Minister of Local Government. I know we are friends because for us,
that was a whisper.
So he says I shouldn't take it up.
Yes.
But you see how conveniently the Minister of Local Government has explained his way out. And he conveniently left out 2D. When do you apply 2D? Of the same Constitution, and it is a latter provision. We agreed that, well, what could have happened then cannot go as a review. And now that the number is reviewed, the composition is reviewed, what can we do? That's where you found us. And the Attorney General and the chairperson, the learned justice, I think they were saying they want to consult. But now when you came and you spoke, now for them they think we are converted. I want to be on record. I'm not yet.
Chairman?
Yes.
I think even when we want to think, let us do it according to the law. I think that's the most important.
Absolutely.
We may have a wish, but can we do it in accordance with the law? For example, that particular amendment we made, you see, when you are bringing a bill, you have a memorandum and the object, and it explains the background to that amendment. So we are bringing this bill as a review in exercising our powers under Article 180. Then you have exercised those powers given to you by the Constitution. We exercise different powers, and when we are having problems, we are trying to seek refuge. And that would be dangerous. That would be dangerous. If, by the way, this one is not a constitutional amendment, D, when you're exercising powers of review, it is not constitutional amendment. Actually, this afternoon, you can exercise that power if you so wish.
But not so.
However,
by emotion.
However, does it have financial implications?
But when it is by
And
government,
if it does financial implication, we again fall back to the constitution. Yeah, and so yes, you may have the sympathy, yes, but at the same time, can we do things correctly? Lastly, I may make a general comment, Mr. Chairman. This issue of gender, why don't we say there shall be one woman, one man, and we close all this debate?
Perfect.
Whether it is parliament, every constituency has one man, one woman.
Perfect.
There are no districts, one MP, there is no, you get it. And we sort out the issue of what? Of gender imbalance. All these institutions, we call it degenderizing. But you see, say about women, then some people are thinking, how do we get the figures Honorable Marquez is giving certainly would raise the reservation. I think that's the point he's making. And it's really, it is not very hard to see if we apply an average legal grade to that argument. It's not very hard to see. We are raising the reservation, and yet the Constitution reserves only 1/3.
Yes.
So, if we want to exercise the powers of review chair, by resolution, you can apply it under D. And we can do that in next week or whatever it is. My only problem is the issue I've raised before. At this process, at this time of this electoral process, are we going forward, backward, forward, backward?
yes,
Well, if I were the
Honorable,
one, I would not be doing that. And if it is, I'm not.
yes, but you see, Honorable Katuntu, you've tried, because I have heard you before in this committee, making the last statements you made about gender. I thought you were going to backtrack. I was going to remind you about women. Actually, ever since you started acting as a woman MP for yes, because the Electoral Commission couldn't conduct election in Bugweri, you started thinking loudly that actually it is possible. When do we take ourselves to have achieved equality? That women should be comfortable with the reservation of 1/3. If that is the argument, so be it. That just a reserve for 1/3 to guarantee their presence in the council. I think we are moving from 1995 when this constitution is made. The law should be progressive. And I want to implore the two ministers here, Electoral Commission, you absolutely have no, you were brought here as an implementer to listen to the debate. But now we have to report. What do we report? That women are just a reserve force in the council. They are not yet, they can't be. And the minister says they can compete for directly. Yes. We have a parliament here of over 290 constituencies. Excuse me, yes. They are about 20. They are only about 20. The mindset of our societies are still meant to oppress the women. I talk like this because my mother passed on a long time, but I think she would be proud to hear me speak for the women.
Even where she is, she must be seeing you.
Mr. Chairman, Chairman, I have a suggestion. You know, we are still here. Parliament is here. We are the people supposed to make the laws, to change them. I would strongly support the view that each district should be represented by two people, a man and a woman. That would give us, we now have 135 districts. That would give us 270 MPs. Then we would add, then you could add national 2 for disability, national 2 for something like that, special interest.
No, when you move to that level, the special interest groups would be out.
Okay.
Yes.
So the same could happen at the district. There is nothing wrong with saying in each district, every sub-county, 2 people, a man and a woman. And we leave this, add this, subtract this, take this sub-county the other side. But at the moment, we are bad. We have to observe the Constitution. So for me, now given the timing of the Electoral Commission, we actually wanted to appeal through you, Chair, that Parliament waives the rules and we proceed with the bill today and consider it and finish it.
It has happened before.
Thank you very much. I'm glad that you have
But
support.
the bill you want on the age, you have consensus. You can move. You can move on the age. You are age man. What did But you should have gone with me at least. You should have exposed me to the stress I've gone through. Now, but the issue of 1/3, how are you going to resolve it? You could also do it this evening.
Change the Constitution.
Special interest review. Not changing the Constitution. You can't change the Constitution over.
Mr. Chairman, I think we have another challenge we shall run into. If now we go to Parliament and we say, let us proceed, as you're saying, the Minister of Finance will first require that he gives us that certificate of finance implication. An additional 10 or 20 councillors has finance implication on the budget. So why don't we go ahead, we maintain the status quo as it was, then we can come later. Yeah. It was unconstitutional.
You say, do councillors get allowances or salaries?
They get allowances.
And allowances for what? Sitting
allowances.
Yes.
Yeah.
Would that be as compared to the cost of? Let's just, because in the same amendment here you can bring and include.
Can we amend the Constitution in that way, Mr. Chairman? Because we are not going to amend that without going back to 182B.
Because you are only stuck there. 182D gives you a mandate to come to Parliament and move for review, as they did for the elderly. We seem not to be concluding on this matter, and should we say that, are you going to come back, or we should write our report, which is obviously you would know where it will take. You have us on the edge. We can go and do that now. Yes, and it will help the nomination process.
Mr. Chairman, the councillors are there waiting for this bill. The speaker is actually called me. She called me about 15 minutes ago. She's waiting for this bill. I would propose that you now write your report as we proceed with the other processes of presenting the bill for first reading, second, third.
The councillors which councillors are waiting for the bill?
They're there.
The chairpersons, LC3
Yes.
and division.
Yes.
I think on the 8th.
But they are together.
On the other one, you are repealing what we put there, which has not even worked. Why can't we repeal Article 102, which you brought? It has not also not worked.
Permit and we proceed, Chair.
Which I processed. Yes.
You are in the
Mr. Chairman, we have a comprehensive amendment of the Local Government Act. It's coming. But this one is absolutely necessary now for the ongoing exercise. And I'm appealing to the committee to give us the support, write your report.
We gave the support assurances there. We also know that it's the same house that sent you to this committee. So that when we go with the harmonized position.
Yeah.
But do you think we have a harmonized position on all the issues raised?
Chairman, I think we do.
By the way, for those of you who do not know, the Honorable Attorney General was a member until a few months ago of this commission. So the problem now, when the chair asks him, the Land Attorney General, do we have agreement? He still thinks that he's a member this side. So
He's an associate.
Kumbe you are, and if Kumbe is the right word to use, you are now the principal legal advisor. Quite a privileged position. The only one with a different mask, face mask here. Yes, I think we have to agree. Yes.
I think it is so unfortunate that, first of all, as women members of Parliament who represent the district, we have seen the burden of someone, member of Parliament representing the district, which has several constituencies represented by men. And Parliament had sought to relieve the burden on the women councillors, as you have rightly put it. As you have rightly put it,
We are talking about the way forward now.
it is unfortunate that we should want to insist that women councillors should represent two sub-counties in the men representing.
Actually, three. I have mine there. All three.
And it is unfortunate hearing the minister.
How can they hear me
justification
say I
given
am
by the
supporting?
minister because of sheer numbers, really, because we, as we said earlier, the figure of a third was minimal, and this is reflected throughout the whole constitution. And I think we have a duty to correct this and ensure that there is equity, that the women councillors represent sub-counties rather than two. These are people who do not get a salary, they just get an allowance, but the amount of work that they have to do, surely, in this day and age, I thought, yeah. Thank you, Honorable Chair.
Yes, this meeting is coming to an end.
Mr. Chairman, my question.
Oh, yes. Oh, yes.
The answer to the name.
Yes.
The issue of
Mr. Chairman.
documents.
Yes.
The first one was names.
Yes, I want the...
We have had several issues being raised on these issues of women representation at local level. But we've not had a concrete summary and how we as a committee can support our colleagues through the whole process that have their names not harmonized with the identity cards.
Yeah, that's what we're...
It is a very, very
Yeah,
important
thank you.
that we think should be...
It's good to have intelligent men like you in the committee.
Especially those from Toronto.
Chair, yeah. Chair of the Electoral Commission. I think most questions are directly to you. Comfort these members. What is the way forward? But you begin with the, why didn't you forward the academic qualifications? President Museveni, whom I know, is well qualified presidential candidate. Why are you creating an impression that his academic documents have problems or what? Why don't you give him? Is here. Why don't you give him the copies of the president's why he came with 7 academic papers?
No.
When a monkey decides to go out, you're exposing. Yes. That is the Lusonga action.
Thank you, Honorable Chair and members. First of all, we did receive a communication from Mr. Muwada Nkunyingi. I do not recall the exact details of the said correspondence, but all I can say, we responded to Mr. Nkunyingi and have not yet had any rejoinder or counter response to what we responded to him. But on the matters that he raised, I do not, that's why I wish I'd come with that correspondence, maybe would have given specific answers and what we responded to him. I think he was raising issues on whether the documents of Museveni were properly verified and whether his nomination was done properly in 2016. And I think some of the issues he raised were canvassed in the petition that was in the courts of law, and in the Supreme Court rather, and our response therefore was along those lines. But we are waiting for him to get back to us whether our response satisfies his queries or his whatever he was looking for or not. Then secondly, on the issue of the names, Honorable Chair, you absolved us. I think this committee has absolved the commission, that all the commission is doing is interpreting the law in its current state or current form, and that it is the duty of this August House to make the necessary amendments in order to conform to the needs and aspirations of the people. Now, in the issue of change of names, therefore, all we have done is cite the law as it is under the Registration of Persons Act, which law has been confirmed by the courts of law, that if one wishes to change names or his or her names, this is the procedure one has to adopt. It is different from making corrections. Even the courts have addressed the issue of correcting errors in the names. That is different. You are not intrinsically changing your identity. You are only addressing an error in maybe in spelling of your name or something like that. So we are mindful of this. Now, if it is the wisdom of this house that women should not be discriminated to say when a woman gets married, and we understand that either legally or culturally, whatever it is, he or she adopts the name, or she takes on the name of the husband. Why should they be included in the law when the marriage certificate is issued in accordance with the law? Why shouldn't that suffice? You get me? Why shouldn't that suffice? Why should a woman who has a marriage certificate issued under the Marriage Act be required again, in order to adopt the name of the husband, to go to a cumbersome process of a deed poll, gazetting? The house can make that. And it's very simple, by removing married woman from this section 36. Yes.
Why not by saying the house can do that? You are actually saying that the General and the Minister of Justice should prepare an amendment to that.
And we are saying for people like Honorable Bichetero, Honorable Veronica, who went through some process way before the 2015 Registration of Persons Act came to effect. Although strictly under the law, she should have proceeded under the registration of the Birth and the Registration of Birth and Death Act. That's what should have been done. But for us as a commission, we are saying, if you swear a statutory declaration, maybe an affidavit, and before 2015, those processes were accepted, and you proceeded to act along those, nobody raised a finger. The problem is, honorable members of this house, you are the ones who raise the finger and say, Aston Kajara, there are issues here. So that's why we are saying, to avoid all this, let us stick to the law in its current form. Because it's also painful and cumbersome. You have secured your victory squarely and fairly. But then someone raises something that really has no bearing on your victory. And the court says, yes, we agree. So these are things that can be sorted out under the law, honorable members. That's what we are saying. But the commission, as you stated, and Honorable Vasari was stated, the commission is really implementers. We are implementers. But the powers like this August House to look at all these, like the issue of women, as I've pointed out, that surely should be looked at. Why should they be subjected to Section 36 as well? when you went through a marriage certificate under the Marriage Act. So these are some of the things. Now, on the issue of numbers, I think that one I don't have to say the direct women. They actually complained to me, Chairman, how can we are women, and then you give us 2 sub-counties to represent, then a man is representing 1 sub-county. What is this?
Discrimination.
Again, it is the law. And as the Honorable Katuntu has guided, if, first of all, Parliament has the powers under Article 182D to review, as they did in the review of the constituency, the counties, and representation of the special interest groups. They did that, but a statement preceded that process.
Actually, the point of correction, what I said that by motion, actually it came, they first came with the by motion, then the House advised that they bring proper small amendment to reflect that.
Absolutely.
So it is doing.
Yeah. So I think I've answered the questions, Honorable Chair.
Mr. Chairman,
Now,
in the interest of time,
are you the spokesperson of Mr. Mawanda?
I'm not Mwanda, I'm a new member. But in the interest of time, I want to tell that
Member.
he has not responded.
Are you privy to the response we made to Mr. Mwanda?
Yes.
You have seen it?
Yes, and indeed, the spirit
doesn't address.
The spirit is used to demand for His Excellency Bongwa in Chabrani.
But spirits are not shared.
So, but if you have answered that form, definitely.
No, but let him, can he respond to us at least? Let him respond to our letter.
Okay,
Let him
respond.
I'm not going to answer your lordship. Please.
Honorable Sylvia.
He is not respecting the chair, Mr. Chairman. She is respecting, no, but she can be him. So, but however, Mr. Chairman, the interest of time, I will meet the chairman again after here.
You be specific now. If somebody asks for verification where the paper is verified,
No, it's not that.
and now be specific and ask for the academic papers, you will be given.
Okay.
We need to conclude.
Yeah, just one quick one. May I ask through you, Chair, may I ask through you that the Electoral Commission takes this homework back to inform?
As a way forward, can we have some statement, guidelines on those who are out there? On names, by the way,
on the names to inform your district officers. Chair.
I think we have prioritized things to sort out. Now we are pushing the burden. The Electoral Commission is unfair. We have to sort out our mess. We created it as
I am reading from a conclusion of a statement by the Ministry of Justice. Chair, can I read from a statement from the Ministry of Justice? From what the EC chairperson said. All I'm asking is, when he says any but all I'm asking is, can these people down there, when the president be informed?
Thank you, Mr. Chairman. Mine was just one statement, Mr. Chairman. Just to remind members here. Mr. Chairman, mine is just to remind members here that as the Electoral Commission
ensonga y'amannya ffe akakiiko k'ebyokulonda tugoberera amateeka ge galagira nti omuntu yenna awezezza myaka 18 bw'aba ayagala kukyusa erinnya ayina okugondera etteeka eriri mu kiragiro ky'okuwandiisa abantu oba tuyita Registration of Persons Act oba ekiragiro kyabanira kye bakolerako. Olwekyo ffe nga bakakiiko sifa abakola mateeka era kyova olaba ba member of parliament bakkiriza nti be bakola mateeka oba bakyetaagisa kulongoosaamu amateeka obuyinza bwe babuyina naye ffe tusaba abantu bagoberera amateeka sigamba twagala kulemesa naddala bakyala oba okubaawulamu oba discriminate against them nedda ekyo si kigendererwa kyaffe. Nolwekyo parliament eyayisa etteeka erina oliddamu erirongooseemu oba kyetaagisa okulongoosa. Kale mwebale. The way forward, Parliament, I think, has recognized that they are the ones who made the law that requires persons who 18 years and above, whether married or unmarried, widow, widower, whichever, that if you want to change your name, then you should follow the law, the procedure prescribed under Section 36 of the Registration of Persons Act. So they have said it is not the fault of the Electoral Commission. The Electoral Commission, we are mere implementers of the law as it is. If the law appears to be discriminatory or disadvantaging a certain section of our members of our society, it is within the powers of Parliament to take it up and make the necessary amendments. Thank you.
Bangambye jjo okutola akateeka nga ng'ogenda waki kunu. Sika. Mukeeka.